Welcome back to Counterpoint. We're joined again by Dr. Michael Geist as we examine two controversial bills, C2 and C4, which are before Parliament right now. Before we went to commercial break, Dr. Geist, we were discussing C2 and how the lawful access rules are being changed with the proposal of this bill. So it sounds like to me, and correct me if I'm wrong, that this bill could lead or will lead to unconstitutional searches and violations of Canadians' rights.
Well, I think there's no doubt that this legislation, if passed in its current form, is going to be subject to a constitutional challenge. I mean, there's just like no doubt about that. As I say, we've had successive Supreme Court of Canada decisions, one in 2014 known as Spencer, the other more recent just last year, Bajkowicz. In both cases, the Supreme Court examined some of the same kinds of information, same kinds of issues, and both times said there's a reasonable expectation of privacy associated with that information, and so some kind of court oversight is appropriate. Now, in this context, they're looking for different kinds of information. On the one hand, they say, listen, all we want to know from some providers is, well, whether or not you actually provide service to a particular person or account identifier.
Mm-hmm.
We know the name, you tell us whether or not you provide service. But then they expand by saying, well, we'd also like to know what kind of data do you have on this person? When did you provide the service? Where did you provide the service? And you can think of this in the context of, let's say, they're investigating someone, they go to a hotel. Did such and such stay at your hotel? Tell us the dates, tell us when they came, when they left, what other service providers did they use as part of this? This would be all part of what would be accessible without any court oversight, and it would put a huge onus on the hotel or on lawyers or on physicians to challenge it with a very limited time if they're willing to do so.
It's truly quite shocking. Are there any other jurisdictions in the world where they have, and I'm talking about, say, the Western, say, G7 or whatever, G20 countries where they have similar legislation?
Yeah, so listen, many countries do address this question of under what circumstances can law enforcement obtain access to information. The problem here is really in some ways twofold. First, the fact that this is so broad-based. I mean, in many other countries, they focus specifically on telecom and internet providers. And in fact, we already have a system in place in Canada to deal with this. Some of the larger players, the Rogers and Bells of the world, have responded to hundreds of thousands of these warrants over the years. And last year, 160,000 customer names were disclosed by Rogers alone under warrant. So it's not
Wow.
clear there's an existing problem in these circumstances. There's a lot of disclosures, but we've got oversight for them. In this instance, they're trying to remove that oversight. And by doing it as broad-based as they are, it would appear that Canada may be one of the only countries that is extending this really to any service provider at all.
Wow. So are there presently in its current form any measures to prevent any misuse of power? Like, are there any checks and balances in this bill?
Well, the checks in a sense, or the balances in a sense, both with the information that's provided. So government would argue, listen, some of the content, let's say, of messages has to be subject to a warrant. There also has to be investigation of any potential violation or violation of an act of parliament. That's a pretty low threshold. Police have to have a reason to suspect. That's about the lowest threshold. So none of these, I think, provide a whole lot of comfort. There is the ability for the provider to challenge this, though, but they've got to do so within 5 days. And they also have to keep the fact that there is this request secret. Now, the notion that you could have law enforcement, let's say, going to many lawyers and saying, is this person a client? I mean, that quite clearly violates solicitor-client privilege. But is the expectation that lawyers are going to have to fight this time and again with only a few days to challenge a demand to disclose?
Wow. And presumably, a lot of these telecom providers or internet service providers, they're going to be busy and overwhelmed. What if they get a deluge of these kinds of requests? How does one, meet the 5 day appeal challenge quickly enough? So you mentioned that it is pretty inevitable that this will be up for a Supreme Court challenge. We've had precedent before where similar things have been introduced and challenged, rightfully so, in my opinion. So why is the government bothering? Why bother when you know it's got to go through committee and inevitably it will be challenged in Supreme Court?
Well, that's a good question. I mean, it does feel like part of this was just throwing this in at the end of a piece of legislation during a bit of a honeymoon period for a new government in the hope that people wouldn't pay attention. And I think that there are elements in that bill that there are many people who are supportive of. And I think they've included this towards the very end. It was not a focal point. It took a lot of people by surprise. In fact, the government at first really struggled to even identify what this had to do with any of the legislation at all. They cited things like fentanyl. I mean, I don't know what this has to do with dealing with that issue. And it just became clear that in many ways, this was a policy that law enforcement had long wanted. There may be people in the department that had wanted it,